back, Mr. Chairman.
Thank you very much. I think Mr. DeSagne has no questions. Ms. Ross?
Mr. Chairman, I have no questions, but I know that my colleague here, Mr. Neguse, does.
I'm going to yield now to Mr. Neguse.
Thank you, Mr. Chairman. Well, it's good to see you again, Mr. Armstrong, whom I consider a dear friend. I do think you have an unenviable task today of defending a case that I think is very difficult to defend under the facts that we're considering today. So just taking a step back, because Ms. Scanlon noted this or articulated it, and I thought it was well said. Mr. Clark, the last time you were here in front of the Rules Committee, I believe, was during the contempt resolution that was introduced and that the Rules Committee was considering regarding Mr. Clark. Yes. You recall that. And I seem to remember a lot of my colleagues, my friends from the other side of the aisle, claiming that the sky was falling and that the House should not proceed with that contempt resolution, so on and so forth. Has the House considered a contempt resolution against Mr. Clark?
No.
Why not?
Because he complied, or he testified.
Because he testified. No, that's right. No, you're precisely right, because he testified. Because he responded to this committee initiating the resolution to the floor by coming in, testifying, and my understanding, I'm not on the select committee, is that he pled the Fifth Amendment, or at least that's what some reporting indicates. So he complied and came in and did what you are supposed to do, which is show up and answer the questions that are posed to you pursuant to a duly issued subpoena, and if you believe you have a privilege to invoke it there and then. So to the extent that the argument is that there's no deterrent impact of a contempt citation proceeding, I think that that's a bit much, and I think that case perhaps provides some evidence to the contrary. I hate to belabor this, because I think Mr. Raskin has articulated this, Mr. Perlmutter has articulated it, Ms. Scanlon has articulated it, but I must. When someone receives a duly issued congressional subpoena, right, they have choices. They can comply with the subpoena, appear in front of the Congress or the committee that has issued the subpoena and answer the questions. Or they can move to quash that subpoena, correct? They can go into court, and many witnesses, my understanding, have received subpoenas or are the subject of subpoenas that have been issued, for example, to wireless carriers for phone records, and they have gone into federal court in an attempt to quash those subpoenas. Those are legitimate options that witnesses can pursue. My understanding of your argument is that you believe there is a third option, which is ignore the subpoena completely, don't move to quash the subpoena in a court of law, simply stand back and say, if you'd like me to testify, you need to initiate a civil enforcement of that subpoena. Is that the argument you're making?
Well, yeah, except no, not entirely. I mean, they didn't ignore the subpoena completely.
Sure.
Scavino engaged in good faith arguments as to what the subpoena was.
I take you at your word. Let's say you negotiate, you go in good faith, you exchange letters and so on and so forth. Ultimately, fundamentally, you're still making a decision at some point to say, you know what, we're not coming in, and we're not initiating a legal proceeding. Well, what are you doing? Well, we're going to basically wait and compel the Congress to initiate an enforcement mechanism to force me, the witness, to come testify. That's your position.
Well, they made very good faith, colorable arguments as to what they had problems with and never had any meaningful response. So
then why not show up and make those arguments? Why not appear and invoke the Fifth Amendment, invoke the executive privilege, even though, as we've discussed ad nauseum during this particular hearing and in hearings in the past, as Mr. Morelli eloquently articulated, I don't think that ultimately that privilege is a privilege that the witness can assert during the pendency of a deposition like this, but fine, show up, assert it, and say, I'm not answering that question. You listed a litany of other objections that these document requests or the testimonial requests are duplicative. Say it's duplicative. I decline to answer this question. I believe it's duplicative. I'm going to force the committee to initiate a lawsuit to compel me to say it. Why not do that?
Well, I'm not there giving advice to Mr. Scavino. I'm not his lawyer. I'm not in those conversations, so I don't have a reason for that. But I can honestly tell you that I know just from reading the letters that they don't think they had any meaningful engagement with the committee.
Well, I'd say this, and I said this at the hearing in December, because I take you at your word As Mr. Raskin said, given your background and I think your fidelity to the law and as a serious lawyer, kind of wrestling with these arguments. But my colleagues on the other side of the aisle are creating a standard that is untenable and will prove to be unsustainable over the long haul. And to the extent, I'm happy to yield to my colleague for a particular question, to Mr. Reschenthaler, because the day may come when my colleagues have the gavel. I hope not too soon. But when that day comes, my construction of your argument, as I understand it today, and in the hearing that we had in December, and in the hearing that we had in November on Mr. Bannett's contempt citation, is that any witness who believes that their testimony would in some way invoke executive privilege need not show up in response to a congressional subpoena and need not move to quash that subpoena. Any witness in the Biden administration, any individual employed by the executive branch, in the State Department, in the Defense Department, in any other agency that my colleagues on the other side of the aisle are interested in potentially questioning need not show up under the standard that apparently you all have adopted over the course of this last 6 months. If I am wrong on that front, I yield to my colleague to correct me.
So thanks, Mr. Neguse. I appreciate it. What I actually wanted to jump in on was the question of why Mr. Scavino just won't come in. Look, I'm not Mr. Scavino's attorney, obviously, but if I were advising him, I'd say there's a few concerns. Okay, number one is just the scope of the questions kept changing, which is a problem because you cannot prepare a witness when you cannot get nailed down what exactly is going to be asked of that witness. So that's one. Number two, there's a lot of due process concerns here. You don't want to waive those arguments by coming in. And finally, there's an argument to be made. I don't know how compelling it is, but the committee's own rules were not followed. And if you look at case law, when the committee, even the quorum is being busted, it's questionable whether anything that comes out of that can withstand in court. So just for those reasons, so there are legal reasons why Mr. Scavino might not come. Thank you for yielding to me. I yield back.
I would just simply say, and I appreciate the gentleman and the argument that he's making. Apparently, all of these witnesses are reading from the same song sheet because Mr. Navarro, Mr. Bannon have all reached the same conclusion that they couldn't be properly prepped, and so therefore they shouldn't appear before the select committee to answer these important questions about the worst attack on our nation's capital since the War of 1812. In any event, I digress.
Would the gentleman yield?
I yield
for
to
a quick
my
question
colleague
to
from
the witness,
Colorado.
Just because I keep sort of getting these mixed up. So you keep talking about Scavino